Hello, this is Tony Coe, founder of Saunders 1865, the VIP Relocation Company in London. This briefing is about the tenant fee ban in the UK that's due to come into force on the 1st of June of this year, 2019. It's an exciting New York law that's only just been finalised by our Parliament after being contemplated for frankly far too long a period. So I thought this would be a good time to give you a quick summary of the new law's main features. You may recall that at Saunders 1865 we fought long and hard for this tenant fee ban, and we were up against frankly very loud objections from landlords agents all over the United Kingdom. During the consultation process, we made a number of submissions to government in support of the ban, and we reached out to our corporate clients, you may have been one of them, as well, and we wanted them to add weight to the case for a ban, and I'm very pleased that many of you did that, and I'm even more pleased to say that our representations have been listened to and largely implemented. The central thrust of our argument was this: letting agents who only represent landlords' interests and who earn substantial commissions from their client landlords should not also be entitled to demand fees from renters. Now, I'm pleased that the government has adopted our position. The new law will ban agents and landlords from charging fees to renters except in very limited circumstances. And the new law has gone even further than that in our direction. So, here are the highlights in very broad brush terms. There are intricacies which I won't go into here, and there's more to the new law than I'm going to cover here, but I don't want to make this briefing today too lengthy. So let's get started. First of all, security deposits, they're not really fees, but they're covered by the new law. Security deposits are now going to be capped at 5 weeks' rent. That's where the annual rent's up to £50,000. If the rent is over £50,000, then the limit is 6 weeks. The landlord can't go above those caps for any reason, even if, for example, the tenant has pets. Deposit replacement products will be allowed. This is where a renter pays a one-off non-refundable fee instead of a cash deposit, but they'll only be allowed if they are an option. Renters can't be forced to buy one. Secondly, tenants must not be charged any fees for referencing or inventories or administration, those dreaded admin fees that letting agents like to load on for nothing. And guarantors can't be charged either. Fees to tenants will no longer be allowed for renewing or extending leases. So that's a good one too. Fees that can be charged are very limited, as I said earlier, to circumstances like if the tenant loses the keys, and then it's only the reasonable cost. And if the tenant falls into rent arrears by more than 14 days, then interest can be charged, but that's limited to 3% over Bank of England base rate, and charges can't be made anymore for writing letters about rent arrears, warning letters. A fee can be charged if there's a change in one of the tenants on the named on the lease, and a charge can be made for a surrender of a lease. That's where the tenant decides that they want to cancel the lease early. But again, all these things will be subject to limits. The fees will have to be reasonable. The new law only applies, or only will apply, to tenancy agreements signed on or after the 1st of June 2019. There will be transitional provisions, as there always are with new legislation, that will apply to those tenancy agreements or leases that were signed before that date. Again, there are some complexities around the transitional provisions, which I won't go into the details of here. Now, it is important for me to say that company lettings, that is where a company is the tenant, will be exempt from the new law. So, for example, where your company, as the employer, takes the lease in its name rather than in the assignee's name, the tenant fee ban will not apply. I think that's quite a strange exemption, but that nevertheless that's what the government has decided. So we will need to think about how we approach this particular issue when it is a company let and we're putting forward an offer. The trade body in the UK for letting agents has itself admitted that a lot of agents will simply just ignore the new law in hopes that they will get away with continuing to demand fees. So for that reason, and it's all very well in introducing new laws, but if there's no enforcement around them, they aren't much good. But we can help with that. And I would say that it's very important to make sure that all your UK assignees are given access to advice and representation in some form, even if that's only access to a basic desktop support service, which is one of the entry-level services that we offer for those assignees where you're not able to offer full relocation support. So that's all on the new tenant fee ban for right now. We will be keeping a very close eye on the official guidance that will be issued by government in the run-up to the introduction of the new legislation, and we'll keep you posted if you're receiving our regular bulletins. In the meantime, if you have any questions, please do get in touch with us here at Saunders 1865. Thank you.